Hello there, my friend. My name is Dina, and I am so happy to meet you. Here in IntlLaw Academy of International Law, we are sharing a journey together. We got familiar with the discipline and got to know its sources, and now I've got the honor to guide the journey by teaching about the subjects of international law. If you want, click on the playlist above to catch up, and if you are ready, let's continue the path by drawing the law alive. When we begin studying the subjects of international law, the first and most fundamental one we encounter is the state. International law does not create states. It only defines the limits of their authority and the principles that regulate their coexistence. The state is the most complete form of political organization, the principal member of the international community, and the original subject of international law. For centuries, it was the only entity that could hold rights and obligations on the international plane, the very foundation upon which the entire structure of international law was built. In its legal sense, a state is a permanent and organized community of people living within a defined territory under an independent political authority. From this understanding, four essential elements emerge: population, territory, government, and sovereignty. Each of these elements is necessary for the existence of a state and for its recognition as a subject of international law. Yet possessing these elements in theory is not always enough. A state must exercise them effectively to be considered a functioning and stable member of the international community. The population represents the human foundation of the state. It is not simply a group of people living together, but a body of individuals bound by legal and political ties, the most important of which is nationality. Depending on the philosophical approach we adopt, we may view the nation as a voluntary association of individuals who choose to live together and share a common future, or as a natural community shaped by common history, culture, and language. In both views, the population gives the state its identity and continuity. It is through this human element that the state finds both its meaning and its permanence, even as governments rise and fall. The territory provides the physical dimension of statehood, the geographical space within which the state exercises its authority. It is the material basis of sovereignty and the boundary that defines where a state's legal power begins and ends. Territory gives political organization a tangible form and connects the state to the earth itself, marking its presence in the international order. The effectiveness of a state's control over its territory often determines the strength of its sovereignty and the reality of its independence. The government embodies the institutional and administrative structure through which the state acts. It ensures order within, represents the state abroad, and expresses its will in the international arena. Without a government capable of exercising authority effectively, the other elements cannot operate coherently. It is important, however, to distinguish between the state and its government. The state endures as a permanent legal person, while governments may change, evolve, or even collapse without extinguishing the state itself. Finally, sovereignty gives the state its legal personality. It means independence, the competence to govern internal affairs freely and to engage in external relations without subordination to any higher power. Sovereignty does not imply isolation. Rather, it is the condition that allows states to participate as equals in the global community of law. While a state may exist once these elements are fulfilled, its recognition by other states determines how fully it can act in the international arena, turning legal existence into practical participation. This classical conception is reflected in the Montevideo Convention on the Rights and Duties of States, 1933, which identifies these four criteria as the essential attributes of statehood: a permanent population, a defined territory, a government, and the capacity to enter into relations with other states. Although this definition has been debated and refined, it continues to provide the basic framework through which we understand the legal existence of a state. These elements, population, territory, government, and sovereignty, together form the living structure of statehood. They shape the state's legal identity, its responsibilities, and its role as the central subject of international law. Let's begin with the land itself. the quiet stage upon which every story of statehood unfolds. Territory is the first canvas where a population takes root, and sovereignty begins to breathe. Without land, the state cannot exist. It is the physical frame that gives legal identity its shape. But how does a state come to possess this territory, to hold full and recognized authority over it under international law? Historically, states acquired land through many paths, some lawful today, others buried in the past. In earlier centuries, conquest and annexation were the most common. Yet since the adoption of the UN Charter, the acquisition of territory by force has been prohibited, reflecting a moral and legal shift from domination to legitimacy. Beyond conquest, territory could also change hands through dynastic marriage, as when Brittany was united with France, or by papal decree, such as the 1494 Treaty of Tordesillas dividing the world between Spain and Portugal. Sometimes, states gained land through transfer or sale, derivative titles based on treaties or agreements, such as the purchase of Alaska from Russia. At other times, acquisition occurred through inheritance or will, like the Congo once being the personal property of the Belgian king before decolonization transformed it into the Democratic Republic of the Congo. Discovery, too, once accepted, evolved into the doctrine of effective occupation, a claim validated not by mere citing, but by actual peaceful and continuous control. International law also contemplates prescription, acquiring territory through long and uncontested possession, though this remains a debated principle. Islands or maritime features near a state's coast may fall under sovereignty through continuity and control. Similarly, occupation of terra nullius, or land belonging to no one, creates title, but only if it is effective and peaceful, since the use of force is now barred in international relations, except within domestic conflicts. Where effective control collides with documentary title, the legal principle prevails. A state with lawful title holds a stronger claim than one relying solely on occupation. Territory can also expand naturally, through geological changes like volcanic eruptions in Iceland or sediment accumulation in deltas such as Bangladesh's. And sometimes it is born of the right to self-determination, when peoples lawfully form a new state within defined borders, as reflected in the Berlin Act and later decolonization instruments. In every form, international law insists on effective authority and public declaration, the tangible and visible exercise of power. Together, these paths, conquest now forbidden, transfer, inheritance, discovery, occupation, prescription, natural expansion, and self-determination, trace the evolution of how land becomes part of a state's legal soul. Territory, in this sense, is not only soil, it is history made visible, law-given boundaries, and sovereignty-given ground to stand upon. Not every possession of land brings with it full and absolute sovereignty. Sometimes, international law recognizes limited territorial competence, situations where a state has control or rights over land, yet sovereignty remains shared, delegated, or restrained. These arrangements reflect the complex balance between power, consent, and cooperation in the global order. One such form is the sphere of influence, areas established by treaty between two states to delineate political or economic dominance without transferring sovereignty, such as the arrangements between France and Britain in West Africa, or between Britain and Russia in the Pamirs. A similar but more specific arrangement is servitude, where one state grants another the right to use part of its territory for a particular purpose. For instance, access to a river or military route. Another model is the zone of special interest, where a state acts not as sovereign, but as protector of its interests, reminiscent of the Anglo-Russian division of influence over Iran during the early 20th century. There is also the tutelary relationship, where a protecting state assumes responsibility for external affairs, while the protected state retains internal governance, as once seen in Samoa. Then comes mandates under the League of Nations and trusteeship under the United Nations, systems where victorious or administering states govern certain territories on behalf of the international community. The International Court of Justice later affirmed that such mandates did not transfer sovereignty, only administrative authority. Another form is condominium, or joint sovereignty, where two or more states exercise authority together over the same territory with no exclusive claim, such as the Anglo-French condominium over the New Hebrides, now Vanuatu. Similarly, leasehold arrangements transfer temporary authority without transferring sovereignty, as in the U.S. lease of Guantanamo Bay or Britain's control over Hong Kong and Macau before their return. Under status of forces agreements, SOFAs, foreign military personnel may enjoy jurisdictional immunity within a host state, again showing a limited and negotiated competence. Finally, international law recognizes internationalized territories, areas placed under special regimes due to their unique political, economic, or environmental importance, sometimes existing within a state's territory, sometimes independent of it. Alongside limited competence, there also exists relative acquisition of territory, situations of shared or partial ownership. Examples include the New Hebrides condominium, the international servitude over the Suez Canal established by the Convention of Constantinople, and the lease of zones like Panama or Hong Kong. Each of these arrangements reminds us that sovereignty in the modern world is rarely absolute. Territory may belong, yet not entirely. It may host layers of authority, coexistence, and trust. In international law, land can be both a foundation and a negotiation, a space of shared interests, balanced duties, and evolving meanings of what it means to own a piece of the world. In international law, not all territories on Earth belong to sovereign states. Some parts of the planet, like the polar regions, raise unique legal questions about ownership, discovery, and protection. These regions, the Arctic and the Antarctic, are among the last frontiers where law, science, and politics converge in delicate balance. For the Arctic, two main theories have shaped claims of sovereignty. The first is the sector theory, supported notably by Russia and Canada, which argues that states with coasts along the Arctic Ocean possess sovereignty over the area extending from their northern coastline to the North Pole within defined longitudinal lines. The second is the effective occupation theory, primarily advanced by Canada, which claims that sovereignty arises not merely from geographical projection, but from actual, continuous, and effective occupation and administration. An idea emerging especially where the sector claim could not apply due to geography, such as in the case of Alaska. Over time, several states, including Russia, Denmark, Norway, Finland, Iceland, and Canada, have made claims over Arctic territories, sometimes symbolically, such as Russia's planting of a flag on the seabed beneath the North Pole. To manage cooperation and prevent conflict, the Arctic Council was established in 1996 in Ottawa, promoting coordination among Arctic states on environmental protection, scientific research, and sustainable development. Though questions of sovereignty remain, the Council reflects the growing trend of shared governance in fragile global spaces. The Antarctic, by contrast, follows a different path. Competing historical theories, such as discovery, championed by France, asserting that discovery grants sovereignty, occupation, favored by Russia, and proximity, adopted by Argentina and Chile, once guided territorial ambitions over the southern continent. Yet, these rivalries were ultimately tempered by cooperation. In 1959, 12 countries signed the Washington Treaty on Antarctica, 7 of which had prior territorial claims. The treaty, a landmark in international law, froze those claims and transformed Antarctica into a zone of peace and science. Later, the Madrid Protocol of 1991 expanded this framework by banning all mineral resource activities for 50 years and setting comprehensive environmental safeguards. It entered into force in 1998, outlining 6 major areas of responsibility: environmental impact assessment, conservation of flora and fauna, waste management, prevention of marine pollution, protection of specially managed areas, and state responsibility for environmental harm. Thus, while the Arctic remains a field of overlapping ambitions, the Antarctic stands as a rare example of collective restraint, a continent not of conquest, but of cooperation, where science replaces sovereignty, and humanity's curiosity replaces possession. Now that we've explored the ways a territory can be acquired, we must ask, how far does territorial jurisdiction stretch? Once sovereignty is established, to what extent can it exercise authority over the land? Here, the boundary between neighboring states becomes crucial. Boundary delimitation determines the reach of territorial jurisdiction, sometimes through unilateral acts, treaties, judicial or arbitral decisions, or established legal principles. Boundaries themselves may be natural or artificial. Natural boundaries appear in multiple forms. A mountain ridge, like the historic Indo-Pakistan or Indochina border, or a watershed line dividing peaks, as between France and Italy, where glaciers mark the divide. Sometimes the mountain's base becomes the boundary, allocating the entire slope to one state. Watercourses also create boundaries. Rivers may be navigable, with the bank as the border, like the Arvand, or non-navigable, where the median line marks the division, and islands or river branches are carefully accounted for. Lakes follow similar rules, the midline of Lake Geneva or Lake Lugano between Switzerland, France, and Italy, for instance. Artificial boundaries, meanwhile, can be geometric, marked with posts or wires, or astronomical, defined by coordinates, like those between North and South Korea or colonial-era African coastlines. Administrative lines, pre-independence divisions, and juridical occupation principles also define limits, a concept emerging from early Latin American practice in the 19th century, reaffirmed in African and post-Soviet contexts, and sometimes triggering disputes, as seen in Yugoslavia and Czechoslovakia. In all these cases, the boundary becomes the brushstroke that frames the canvas of sovereignty. Beyond land, the reach of jurisdiction stretches into seas and oceans. Territorial waters, exclusive economic zones, and continental shelves extend sovereignty into the maritime domain, shaping access to resources, navigation rights, and international responsibilities. This expansion of territory reminds us that sovereignty is both tangible and fluid, a living canvas that reaches beyond the shoreline. The legal principle of ut possidetis juris further safeguards stability, ensuring that newly independent states inherit pre-existing administrative borders. By preserving these inherited lines, the principle prevents arbitrary changes and reduces the risk of conflicts, linking historical legacies to modern international law. When disputes arise, international law offers tools for peaceful resolution: arbitration, adjudication by the International Court of Justice, or negotiated treaties. These mechanisms are the gentle hands that guide the brushstrokes, ensuring that sovereignty is exercised without sparking conflict and that borders are respected by neighbors and the global community alike. Boundaries are not static. They evolve with nature and circumstance. Rivers may shift, glaciers may retreat, coastlines may erode, all nudging the lines that once seemed fixed. States must adapt, sometimes renegotiating, always attentive to the delicate interplay between geography, law, and politics. Let's take a moment to gather a few essential thoughts about the territorial element of a state, the stage upon which all acts of sovereignty unfold. A state's land is expected to be coherent and contiguous, even if enclaves or islands exist. It must remain stable and permanent over time, with clearly defined and recognized boundaries. Sovereignty is not just a claim on paper. It requires effective control, the ability to govern, enforce law, and maintain order. And within this territory lie resources, waterways, and the environment, all under the state's jurisdiction. Territories may shift through treaties, agreements, or historical changes, but the core principle remains. The land defines where a state exists, where its authority reaches, and where its people belong. So now we have explored the first element that defines a state, its territory. In our next videos, we will continue this journey, drawing and exploring the remaining elements that complete the picture of a state, step by step, brushstroke by brushstroke, just as we've begun here.